Daily list for admission, item number 1.
Your Lordship, I would like to tender my sincere apologies. I was supposed to file my affidavit last Friday, but since I have some personal difficulty in attending the court, and I have filed this affidavit now only, Your Lordship.
My Lord, in this contempt petition, the judgment which we are seeking to implement is the judgment of 2023, March 17th. And now in the year 2026, my Lord. Since the last 2 years, they have been seeking time for filing this affidavit. And this morning, and my Lord, this Honorable Court had passed 3 orders since last year. And if Your Lordship may kindly see the last 3-4 occasions of this Honorable Court, my Lord, they have been given.
When will you be filing?
We have filed, yes,
Yeah.
as we speak. I have served a copy of this.
Today?
Yes.
Okay.
I have just furnished the advance copy, my Lord. On bare perusal of this, my Lord, what can be seen is that the last step taken by them was on 2024. No steps have been taken during the last 2025. So if they file this today, my Lord, let it be taken up tomorrow or day after tomorrow, my Lord.
Fine.
Otherwise, my Lord, this is a judgment of 2023. They have not taken any steps during the last year, my Lord, 2025.
Your Lordship, my learned friend, since I have served him a copy this morning only.
No,
my learned
after
friend-
filing of the affidavit,
Yes,
this matter can be listed for hearing.
yes.
She is submitting that she has been filed. The affidavit they have just filed this morning.
Today.
Yes, my
Just
Lord.
now.
So
That is what she is submitting. So if this matter may be taken up on day after tomorrow.
no, not day after tomorrow. Next week. For hearing, let us fix it for hearing if the pleadings are complete. Choose any day in the next week.
Next Thursday, Your Lordship.
Heard Miss Victor.
17, my Lord, 17.
Okay, Victor S. El Ralte, learned counsel for the petitioner. Also heard Miss Mary L. Chiante, learned counsel appearing for respondent number 1, 3, 4, 7 and 11. Who else is appearing?
Your Lordship,
Who?
Samara is represented by Jonathan. Learned John.
Learned counsel for the respondent has submitted that she has filed the affidavit in opposition today itself and also furnished a copy thereof to the learned counsel for the petitioner. She submits that this matter may be listed for hearing. Let this matter be listed for hearing on 17th of February.
DB of life. In the part 1 column, my Lord.
It will come in the regular list only.
Yes, my Lord.
Item 2.
Yes. Who is appearing for the respondent?
On the last occasion, my Lord, Ms. Lan Louis appeared for the respondents and submitted that she will be filing her affidavit. I was already served the advance copy of the affidavit, my Lord.
You have been served.
But, my Lord, the affidavit which they propose to file, there is a defect in the affidavit, my Lord, which is inadmissible by this honorable court. This is a contempt proceeding, my Lord. There are 5 contempt respondents, my Lord, in this contempt case. And while they are supposed to file affidavit separately as an individual, they had filed this affidavit, common joint affidavit, my Lord, which is impermissible in contempt proceeding. I don't know whether they have already filed or not, but I was served this advance copy. And the stand taken by them, their affidavit, in their affidavit, my Lord, is the stand which they have taken in the writ proceeding, which was already overruled by the judgment.
Now what is to be done? The respondent is not present.
Personal appearance, my lord.
We'll wait for some time.
For some time.
Miss
Thank you.
Lalun
Yes, my lord.
Louis is appearing now.
Yes, my lord.
We'll wait whether she comes or not. We'll take it up after some time.
Yes, my lord.
Item 3.
May it please your lordship. My lord, on the last occasion, the learned additional AG was directed to find out as to whether the affidavits filed in the
If this matter can be passed over for the time being, the learned additional AG concerned is on the explanation.
Okay.
Item 4.
My lord,
Yes.
rejoinder affidavit, I was seeking for to file a rejoinder affidavit, and within 2 days I'll file rejoinder affidavit against the respondent number 1 affidavit.
You are seeking time.
Your lordship, I have filed my show cause reply affidavit, and now she is submitting
Reply.
that she will file her reply to my
Within
affidavit.
2 days,
Within 2 days.
yes,
Okay. What is your name?
Jacinta.
Jacinta. Heard Miss Jacinta Zothan Mavi, learned counsel for the petitioner. Also heard Miss Mary L. Kangte, learned counsel for respondent number 1, as well as Miss Zairem Sangpui, learned counsel for respondent number 2. Learned counsel for the petitioner has sought for 2 days' time to file a rejoinder affidavit against the affidavit in opposition filed by the respondent number 1. The prayer is allowed. Let this matter be listed again on next week. Give a date,
19-2.
19th of February.
My lord, can it be changed that date 19? I will not be available.
You suggested it.
Yeah. 17.
Okay, 17.
Item 5.
My lord, I was instructed to defend the case on behalf of respondent number 2. In the meantime, the respondent number 2 has been posted out. The new incumbent may be impeded, my lord. In the meantime, I may be granted 2 weeks' time for filing my vakalut nama,
2 weeks' time for filing?
my power, my vakalut nama.
Heard Mr. Victor L. Ralte.
My lord, before that, my lord, Malanathan is in respect of respondent number 2. And as for the other respondents, my lord, on the last occasion, if your lordship may kindly see the order dated 1/12/2025.
Yes.
The respondent number 3, Ms. Vanessa had entered appearance on behalf of respondent number 3, and also Ms. Mary in respect of respondent number 4. However, they have not yet filed the affidavit. And as for the respondent 5 and 6, my lord, service report is still awaited.
You have taken steps
I had taken steps.
by speed post. Yes, respondent number
I had taken steps on 17th of October.
okay.
22nd October.
Yes, Miss Mary, you have anything to say?
Your lordship, I have sent the affidavit for,
Waiting.
yes. So if I may be given another 2 weeks' time.
Okay. Heard Mr. Victor L. Ralte, learned counsel for the petitioner. Also heard Miss Mary L. Chiante, appearing for respondent number 4, who seeks 2 weeks' time for filing affidavit in opposition. The prayer is allowed. Also heard Ms. Zairem Sanpui, who submits that she has been instructed to appear for respondent number 2. However, she submits that in the meanwhile, the incumbent of the post of respondent number 2 has been posted out, and there is a necessity of impleading the new incumbent. She also seeks 2 weeks' time to submit her power in this case. The prayer is allowed. It appears from office note dated 7/2/2026 that the notice issued to respondent number 5 and 6 have not yet returned. The registry is directed to place before the court the postal track consignment report of the notices sent to respondent number 5 and 6 through speed post on the next date fixed. And what is the stand of respondent number 3, Varneswamy?
Lordship, we will be file our affidavit for respondent number 3 within 2 weeks.
Learned counsel for respondent number 3 also seeks 2 weeks' time for filing affidavit in opposition. The prayer is allowed. Let this matter be listed after 2 weeks.
Item 6.
Please, Your Lordship. Your Lordship, I have the instructions to appear on behalf of respondent number 1 to 4. I'll be filing my power today. And in the meantime, if I may be given at least 3 weeks' time to file my show cause reply affidavit, Your Lordship.
How many respondents are there? 4 only.
It's, yes, 4. I'll be representing all the respondents in the matter.
Heard Mr. Victor L. Ralte, learned counsel for the petitioner. Also heard Ms. Mary L. Chiante, learned counsel, who submits that she has been instructed to appear on behalf of all the respondents, and she seeks some time to file her power in respect of all the respondents. She also seeks 2 weeks' time, 3 weeks' time for filing affidavit in opposition. The prayer is allowed. Let this matter be listed after 3 weeks.
Date may be fixed, my lord.
Listed, fixed date.
5th of March.
5th of March.
Give your back.
For orders, item 7.
May please, Lordship. Lordship, although today is fixed for the hearing, unfortunately, my senior is in another courtroom having hearing, my lord. So if this matter can come up on Friday, this Friday, my lord.
No hearing on Friday.
Then maybe after 2 weeks, maybe, my lord.
No, next week you may choose any day. What is the difficulty? Why you are seeking adjournment?
My senior, he is having a hearing in another courtroom.
Okay. Heard Mr. What is your name?
Lel Mangay Sanga.
Write his name. Learned counsel appearing on behalf of Mr. Johnny L. Tocha, who prays for an adjournment on the ground that the engaged counsel for the petitioner for the applicant is on leg in some other court. Considering the submissions, the prayer is allowed. Let this matter be listed on next week,
19/2.
19th of February.
That's a place.
Item 8.
My lord, we have filed the present application for substitution of the appellant, who had unfortunately passed away on 9/11/2025.
Who passed away? Appellant.
The appellant.
You have filed any?
We have filed the substitution application.
This one is.
Yes, my lord.
Yes. Anything?
My lord, we will not be objecting this IA.
It is within time. When he expired?
On 9/11/2025.
When have you filed this substitution application? 5th of February. What is the limitation period for filing substitution?
90 days, my lord.
90 days has not lapsed. Is it within 90 days?
Mm, 90 days have not passed yet. my lord.
Okay. Heard Ms. Vanlal Tlamuani, learned counsel for the applicant. Also heard Ms. What is her name?
Laltan Louis.
Laltan Louis, learned counsel for respondent number 2. This application under Order 22, Rule 3 of the Code of Civil Procedure, read with Section 151 of the said code, has been filed for substitution of the deceased appellant in the connected regular first appeal number 27/2024. Learned counsel for the applicant has submitted that the appellant of RFA number 27/2024 had expired on 9/11/2025, and therefore the necessity of substituting his legal heir is there in the connected RFA. She submits that the instant substitution application has been filed within the period of limitation of 90 days from the death of the appellant. Stop. The prayer is not opposed to by learned counsel for the respondents. Hence, same is allowed. Who is to be substituted?
By his wife,
Where is the name?
RKLLB Aksangi.
The prayer is allowed. Let the wife of the deceased appellant, namely Srimati R.K. Lalbyak Sangi, be substituted in the place of deceased appellant in the connected regular first appeal number 27/2024. The applicant shall file a corrected memo of corrected cause title in the memo of appeal filed in the connected RFA.
My lord, if I may, the deceased appellant name is Zosang Liana, and he will be substituted by his wife, Srimati RKLLB Aksangi.
Yes, yes. That I have said. This interlocutory application is accordingly disposed of. Let the connected appeal be listed after 2 weeks after filing of the corrected cause title by the applicants. List accordingly.
Supplementary list. Item 9.
Oh, item 9, yes.
Yes, my lord, I'm appearing for the respondents as a legal aid counsel. We have taken instruction from our clients and they have objected to mediation.
And what is the stand of the petitioner?
Your Lordship, same here.
What same?
Our client have declined the refer to mediation
Why?
because, sir, Your Lordship, before the Lok Adalat awarded my half of my property to the respondents without my permission, and even
So
forced.
issue involved is complex.
Yes, Your Lordship.
Yes, ma'am.
Heard, miss, what is your name?
Vanlat Sandami, Your Lordship. And if it pleases Your Lordship, the stay order which was previously passed earlier may continue.
No, that will done. Heard, miss, write her name. Also heard Miss Emily L. Chante, Learned Legal Aid Counsel. This matter has been listed today for the purpose of ascertaining as to whether the matter is fixed, matter is a fit matter to be referred to mediation under the drive Mediation for Nation. Stop. However, Learned Counsel for both the parties have submitted that the parties herein are not inclined to go for a mediation. They also submit that the issue involved in this case would require adjudication by this court and is not a fit matter to be referred to a mediation. Stop. Considering the submissions made by Learned Counsel for both sides, this court is of considered opinion that this is not a fit case to be referred for mediation. Let it be listed. It will be listed for admission hearing.
In the meantime, my lord, I have to submit my affidavit if I may be granted 2 weeks' time.
For admission hearing, the respondent may file their affidavit in opposition in the meanwhile. List accordingly.
Obliged.
Item 10.
My lord, we have instruction that we are not inclined to resolve the mediation through mediation.
Not inclined.
Yeah, not inclined to resolve the matter through mediation.
Why?
As instructed from.
Yes, Mr. Zuram Channa.
On my part, Lordship, I'm willing to get the matter referred to mediation.
You are inclined?
Yes, definitely. Let it be referred and then if they can make a settlement, it's okay. But if they cannot, then it will definitely come back to this limit.
What is the matter?
The issue involved, Lordship, is land dispute, Lordship, between private parties.
No, which order you are impugning in this case? You have impugned some order.
Yes, Lordship. Herein there are some orders which are issued, which actually is in violation of the statutory provisions of the local inheritance property act.
Then this may not be fit for.
But actually, since even
this
that
involves legality of
yes,
of
question
a
of law.
judicial.
Actually, is a question involving technical matters. But
Okay.
even that, my lord, even in that situation, the actual dispute is land dispute, Your Lordship.
Then the mediation has to be done in the connected main case before the trial court, not in the CRP.
That they can, if I'm not mistaken, Lordship, the trial court record is also here with the Lordship here. So that altogether they can refer it, they can also be referred that, and then the mediation can take the matter altogether, my Lord, at one time.
Do you have a stay? Is
Yes,
there any
stay is there, Lordship. Stay order is there.
No. There shall be no mediation. Heard Mr. C. Zoram Chala, learned counsel for the petitioner. Also heard Miss, what is your name?
K. Sandy Rose.
K. Nuki Sandy Rose, learned counsel for the respondent. Though learned counsel for the petitioner has submitted that the petitioner is ready for, petitioner has no objection for referring this matter to mediation. However, learned counsel for the respondent has submitted that the respondent is not inclined to the said offer. Stop. It appears that in this CRP, legality of a judicial order has been challenged, and as such, considering the opposition by the respondent side, this court is also of the opinion that this matter is not a fit matter to be referred to mediation. Accordingly, let this matter be listed. At what stage it was fixed?
They are now to file affidavit, Lordship, which they have not done till date, my Lord.
Listed for admission hearing after 2 weeks. Give a date.
26/2.
26/2. In the meanwhile, the respondent may file their affidavit in opposition. List accordingly.
Obliged.
Item 11.
My Lord, as per the last court's order, we have received instructions from the parties if this matter can be referred to mediation. However, the parties want to pursue the matter on merits.
What is the issue?
My Lord, it is a property dispute.
Yes, Ms. Linda. You have anything to say?
My Lord, State, we have no objection to refer to mediation, but the main issue is with regard to the private respondents related with...
Who is appearing for private?
Mr. Valal Mahaka is for respondents.
Heard Miss.
Banal Samani.
Wallan Thlamuani, learned counsel for the petitioner. Also heard Miss Linda L. Farmwell, learned additional AG, appearing for the state respondent. No one has appeared for the respondent number 7. Learned counsel for the petitioner submits that the petitioner is averse to referring this matter to mediation as it involves complex issues and is a property dispute, and it would be proper if the court adjudicates the matter on merits. On the other hand, Ms. Linda L. Farmwell submits that state has no objection in referring the matter to mediation. However, as the private respondent who has much stakes in the issue is not present before this court, this court is of considered opinion that, considering the reluctance of the petitioner in referring this matter to mediation, no fruitful result would yield in the mediation, and hence same is not referred to mediation. Let this matter be listed. At what stage it was listed?
We are yet to file affidavit for publication of newspaper for orders.
For orders after 2 weeks.
Item 12 and 13.
In this matter, it is same as the previous matter. The petitioners refused to refer this matter to mediation.
But should the state have no objection for referring for mediation?
When state is not objecting, why are you averse to mediation?
My lord, the parties hearing as well wants to pursue the matter on merits.
Why? If you are otherwise getting relief in mediation, parties want to pursue or counsel want to pursue.
My lord, the parties prefer the usual course.
Whether a matter can be referred to mediation if one of the parties is objecting to.
It's up to this court.
Section CPC. If there are elements of settlement, then a matter may be referred to mediation. But if the parties are objecting to whether it can be referred or not, this is a question to both of you. You don't have answer, then we'll take the matter after some time. Come with answers. Both of you. We'll not pass any orders. You come with answer to my...
It's under section 89 of CPC.
No, come with prepared answer. We'll take it after some time.
Item 14.
Yes.
Lordship, there is a matter regarding land dispute. The matter has gone even up to the Apex Court and has come back from the Apex Court, directing the single bench of this Honorable Court to make decision. In spite of that, if there is a possibility of amicable settlement, we have no objection.
Yes.
My Lord, on behalf of respondent number 3 and 4, which is the Chokma Autonomous District Council, we have asked them, but still not get instructions from our client. So, may kindly be the matter be adjourned for time being. Kindly, Your Lordship.
You take instruction. On Monday you tell the court.
Yes, my Lord.
Heard, Mr. This is item number?
14.
C. Lalram Zawa, learned senior counsel, appearing for. Who is assisting you? Mr. Zawa. Senior counsel assisted by Ms. Emily L. Changte, learned counsel for the appellant. Also heard Mr. What is your name?
Emmanuel Chazwala.
Emmanuel Lalthazwala, learned counsel for respondent number
3 and 4.
3 and 4. Learned senior counsel for the appellant submitted that though this matter is a highly contested matter and went up to the apex court, however, the appellants do not have any objection if the matter is referred to mediation. On the other hand, learned counsel for respondent number 3 and 4 has submitted that he is not been able to take instructions from the respondent as regards the question whether the matter may be referred to mediation or not, and seeks some time for getting the said instruction. The prayer is allowed. Let this matter be listed on Tuesday, 17th of February.
Item 15.
My lord, my clients are willing to refer the matter for mediation. I am for the appellant.
You don't have objection?
No objection.
Yes, Mr.
We have no objection also.
Heard Mr. Victor L. Ralte, learned counsel for the petition appellant. Also heard Mr. C. Lalram Zawa, learned senior counsel assisted by Ms. Emily L. Changte, learned counsel for respondent number 1, as well as who is appearing for state, as well as Ms. Linda L. Farmville appearing for the state respondent. It is submitted at bar that the parties here do not have any objection if the matter is referred to mediation, as there is an element of settlement in the instant dispute. Accordingly, there is a High Court Mediation Center. Is there? Accordingly, this matter is referred to the High Court Mediation Center of Aizawl Bench of Guwahati High Court. Who will give you dates, the mediation center, or should we fix the dates? Okay. The parties are directed to appear before the mediation after getting notice of the same from the Guwahati High Court Mediation Center. The mediation report shall be placed before this court after 3 months. You give a date. 2 months. No. Give a date after 3 months. 3 months. We are fixing a date after 3 months. Mediation. Let this matter be listed again on 18th of May for report of the mediation center.
Lordship, here in item number 16, matter was earlier referred to mediation.
Item 16.
Yes, what happened? It was.
I have no objection if the matter is referred to media center, my lord. and similar order can be passed. If the matter is not settled there, it will come back to square one.
Yes, Mr. Zuava, you have any objection?
Yes, I have no objection, but this will be the second time the matter will be referred to.
Once it failed.
Once it failed.
Second time it may be successful.
Yes, let's make an attempt. I have no objection.
Heard Mr. L.H. Lian Shima, learned senior counsel, assisted by Mr. D. Lalzik Bama Kima, learned counsel for the appellant. Also heard Mr. C. Lalram Zava, learned senior counsel, assisted by Miss Emily L. Chante, as well as Miss Linda L. Farmwell, learned additional AG representing the state respondents. Learned counsel for the also heard Mr. Victor L. Ralte appearing for respondent number 7. Learned counsel for all the parties have submitted that though this matter was earlier referred to me for mediation once, and that time the mediation failed, however, there is still hope that an amicable settlement may be arrived at between the parties. Accordingly, this matter is referred to the mediation center of the Aizawl bench of Guwahati High Court. The parties are directed to appear before the mediator after getting notice from the mediation center. Let this matter be listed on after 3 months.
Same date?
What was the date?
18 May.
On 18th May for report of the mediation center.
Item 17.
Yes, my lord.
Yes.
I am on behalf of the appellant, and we have no objection if the matter may be.
Yes, Ms. Emily.
Yes, my lord, we have no objection regarding this.
Heard Mr. A.H. Borbhuya, learned counsel for the appellant. Also heard Ms. Emily L. Chante, learned counsel for the respondent. It is submitted at bar that both the parties have no objection if the matter is referred to mediation, as there is an element of settlement in the instant dispute. Stop. Accordingly, this matter is referred to mediation center of the Aizawl bench of Guwahati High Court. The parties are directed to appear before the mediator after getting notice from the mediation center of the Aizawl bench of Guwahati High Court. Let this matter be listed
18th May.
On 18th May for report of the mediation center.
Item 18.
My lord, the petitioners herein as well refuse to refer the matter to mediation.
Refused?
Yes, my lord.
Yes. You.
For me, I have no objection if the matter is referred to mediation, but if the appellant
You got answer to my query?
My lord, since the mediation is voluntary.
No, what is the legal position? I am not asking what is proper. Is there any bar when a matter is to be referred for mediation?
Not that I'm aware of, my lord, right now.
Huh?
My lord, I'm not sure.
You find out answer.
Yes, my lord.
Though we are not referring this matter to mediation. Heard right hand name. Also heard Mr. L.H. Lian Shrima, learned senior counsel, assisted by Ruth Lalruat Feli, learned counsel for the respondent. Though learned senior counsel for the respondent submits that the respondent does not have. How many respondents are there? Many.
There are 5.
The respondent do not have any objection in referring the matter to the mediation. However, learned counsel for the appellant submits that appellant is averse to referring the matter to mediation and prays for deciding the dispute on its own merits. So, considering the submissions made by learned counsel for both sides, this court is of the opinion that this is not a fit case to be referred to mediation. Accordingly, let this matter. At what stage it was pending?
Hearing, my lord.
Hearing.
Let this matter be listed for hearing after 2 weeks on a date to be fixed by registry.
Obliged.
Item 19.
My lord, the petitioners again refused to settle the matter, refer the matter to mediation.
You got answer?
Lordship, in this matter, I have not yet received instructions as to whether the state respondents are willing.
But they are opposing. Heard. Miss Vanlal Tlamwani, learned counsel for the appellant, also heard Miss Caroline, learned government advocate appearing for the respondent. Learned government advocate submits that she has not yet received instructions from the respondent as to whether they have any objection regarding referring this matter to mediation or not. However, learned counsel for the petitioner, learned counsel for the appellant submits that the appellants are averse to referring this matter to mediation and request to adjudicate the matter on its own merit. Considering the submissions made by learned counsel for the parties, this court does not find this matter a fit matter to be referred to mediation. Accordingly, it was for hearing. Let this matter be listed for hearing after 2 weeks on a date to be fixed by registry.
Item 20.
These are hearing matters. Yes.
Lordship, the appellant is willing to refer the matter for mediation.
Yes.
My lord, we are opposing to refer the matter in mediation since this is a property dispute between siblings.
You have a standard instruction.
My lord.
Heard Mr.
Arlal Munsiyama.
This is item number 20.
Yes, my lord.
T. Lalnunsyama, R. Lalnunsyama, learned counsel for the appellant. Also heard Miss Vanlal Tlamwani, learned counsel for the respondent. Though learned counsel for the appellant submits that the appellant does not have any objection to referring this matter for mediation. However, learned counsel for the respondent submits that the respondents are averse to referring this matter to mediation and prays for deciding the dispute on merits. Stop. Since the matter is already listed for hearing and since one of the parties is not inclined for referring this case to mediation, this court is of considered opinion that this is not a fit case for referring to mediation. Accordingly, let this matter be listed for hearing after 2 weeks on a date to be fixed by registry.
Obliged.
Item 21.
My lord, the matter is regarding land dispute. May this matter be sent for mediation.
No objection, my lord. And for the respondent number 1, I have no objection.
No, but land dispute can be settled in mediations. There is
Yeah,
no bar.
Yeah, only the dispute there is only one matter.
It's a question of overlapping.
Huh?
It's a question of overlapping.
Overlapping.
Yes, my lord. And the revenue, at this stage, my lord, all the revenue settlement orders are in my favor. But as long as they want to go for mediation, my lord, we are willing.
Heard Miss Jacinta Zothan Mavi, learned counsel for the appellant. Also heard Mr. Victor L. Ralte, learned counsel for respondent number 1, as well as who is appearing
I'm
for.
for the respondent number 5, AMC.
What is the name?
Samuel Lompuya. On behalf of my senior Zoram Chana.
Write his name. And Miss Lalnan Louis, learned government advocate, appearing for respondent number 224. Though learned counsel for respondent number 1 has submitted that the respondent number 1 does not have any objection in referring the matter to mediation. However, learned counsel for the appellant submits that appellant is averse to referring this matter to mediation and prays for adjudicating this matter on merit. Considering the submissions made by learned.
If I may, my lord, the appellants are willing to send the matter for mediation.
Willing?
Yes, I'm willing. I already submitted.
Okay. Learned state is not objecting. Learned काट दो, पूरा काट दो. It is submitted at bar by all the council that both the parties are keen in referring this matter to mediation, as there is a hope for an amicable settlement in this case. Accordingly, let this matter be referred to mediation. The parties shall appear before the mediator after getting notice from the mediation center of the Aizawl bench of Guwahati High Court. Let this matter be listed for report of the mediation center on 18th of May.
Much obliged.
Much obliged.
Item 12 and 13.
No, whether consent of the parties are necessary, that was my query. What is the answer?
That I cannot answer now, madam.
No, you have to answer when court has posed a query. Yes, Miss Caroline. You have to assist the court.
Lordship, under section 89 of CPC, settlement of disputes outside the court, where it appears to the court that the dispute between the parties may be settled and there exist elements of settlement which may be acceptable.
So it is
to
for the
parties.
court to decide.
Yes, my lord.
If there is an element. So is there any requirement of seeking consent of the parties? Suppose one party is opposing, still courts come to is of the opinion that opposing party, because in mediation is a structured process.
Yes.
Where some mediator would let you know what are the benefits of mediation, then the mind of the opposing party may change also.
Why I'm saying is that, my lord, this is a dispute of more than 20 years, my lord. So previously also we had made many attempts to the government as well. But
Of conciliation,
yes, and through direct contact also, my lord.
Okay.
It's regarding a contractual dispute, my lord.
Heard Mr. C. Tlang Thiang Lima, learned counsel for the appellant. Also heard Ms. Caroline, learned government advocate, appearing for respondent number 1 and 4. Government has no objection, though the state respondent does not have any objection in referring this matter to mediation. However, learned counsel for the appellant submits that the dispute between the parties is a old pending dispute and the matter is already listed for hearing. He further submits that earlier also attempts were made for an amicable settlement which failed. He submits that considering the nature of dispute involved in this case, this is not a fit case to be referred to mediation. Stop. Considering the submissions made by learned counsel for both sides, this court is of considered opinion that this is not a fit case for referring the same to mediation. Accordingly, let this matter be listed for hearing after 2 weeks on a date to be fixed by registry.
Item 2 from the daily list.
What was her name? Government council. Thank you. Yes. What happened?
Yes, Your Lordship. The affidavit has been filed by the state respondents.
You have filed it?
Yes, Your Lordship.
When?
Your Lordship, it was filed on Friday, 6th.
Then what is to be done?
Your Lordship,
We'll fix the matter for hearing.
My lord, if the same advance copy which they have served to me is filed before this court, my lord, this is not as per the prescribed procedure, my lord. This cannot be accepted. If the same copy, advance copy,
The contemners have not filed individual, they have filed a joint affidavit.
Yes, Your Lordship. I would have to file another for each and every contender, Your Lordship. So if I may be granted at least another 1 week's time then.
Okay. Heard Mr. Victor L. Ralte, learned counsel for the petitioner, also heard Ms. Lal Nan Lui, learned government advocate, who submits that a joint affidavit on behalf of the respondent has been filed. However, since this is a contempt matter, she may be allowed to file individual affidavits by each of the contemners, and she seeks a week's time for the same. The prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry.
Much obliged.
Item 3.
What is this? What is the matter?
My lord, this is regarding the construction of a road within the lands of the petitioners, my lord.
My lord, the respondents have constructed the road under PMGSY scheme, and the affidavit in reply of the state respondents, my lord, they have accepted that lands have indeed passed through lands of private persons, and that construction of that road has also affected the lands of some private persons. That has been accepted. So, my lord, what we are praying for is that a spot verification over the lands of the petitioners may be conducted, and that compensation may be paid as per law to the affected areas.
What is the stand of the state?
My lord, it was on
Who has constructed the road? State or some central agency?
It's the state, my lord.
State. What is your stand?
On the last court date, my lord, I had submitted that since the land was already donated, a portion of the lands were donated for construction, my lord. So my submission was that they do not have locus to even file this present writ petition, my lord. And your lordship had given me some time to see who are the writ petitioners who have signed the land donation agreement, my lord. As far as the instruction goes, my lord, only petitioner number 4 and 17 have signed, my lord.
4 and 17. As
Yes.
regards others?
Others have not been furnished anything, my lord.
So, what is your stand as regards others?
My lord, it's a limited prayer as per the writ petition for conducting a spot verification, my lord.
So, are you opposing to that?
No, my lord, I'm not.
Then we are allowing this writ petition.
For conducting a spot verification and if entitled, my lord.
Then to take steps.
Yes, my lord.
Heard Mr. T. Lal Zekima, learned counsel for the petitioner. Also heard Mr. Samuel Van Lal Riata Changte, learned additional AG, appearing for the state respondent. This writ petition under Article 226 of the Constitution of India has been filed by the petitioners, namely Shri Lal Ham Khai Sangha and 16 others, praying for issuance of writ in the nature of mandamus or any other writ directing the respondents to, where is the prayer?
Page 18, my lord.
Directing the state respondents to conduct a spot verification over the lands of the petitioners and thereafter acquire the lands which have been used for construction of how to pronounce it?
Haulong, my lord.
Haulong, Haulawng, to Dwan PMGSY road and to pay adequate compensations to them. Learned Counsel for the petitioners has submitted that all the petitioners are holders of land passes under periodic patta which are located at Haulong to Dwan Road in Lunglei district. The details of land holding of the petitioners are shown in the table herein below. Quote the table from paragraph number 2 of the writ petition. It is submitted by the learned counsel for the petitioner that the respondent number 8 had issued notice inviting tender for construction of roads under Pradhan Mantri Gram Sadak Yojana within bracket PMGSY for in various districts of Mizoram, including construction of roads including construction of Haulong to Dwan Road. It is contended by the learned counsel it is submitted by learned counsel for the petitioner that the lands of the petitioners were used for the purpose of dumping loose earth/soil without obtaining prior permission of the petitioners, and for such a use of the land of the petitioners for construction of Haulong to Dwan Road, their lands have been affected. However, the said land has not been acquired by the state respondent, neither any compensation has been paid by the state respondent to the petitioners. It is submitted by learned counsel for the petitioner that actions of the state respondent are in violation of the provisions of Article 14 as well as Article 300A of the Constitution of India. He submits that the Article 300A of the Constitution of India provides that no person shall be, within inverted comma, no person shall be deprived of his property save by authority of law, inverted comma close. However, the petitioner's lands were used for construction of aforesaid PMGSY roads without paying due compensation to them, and therefore it is prayed by the petitioner that the state respondent may be directed to conduct a spot verification to ascertain as to whether the lands of the petitioner have been affected due to the construction of which road? How long to Dawn Road under PMGSY scheme, and thereafter, if it is found that their land have been affected, to initiate process for granting adequate compensation as per law. Stop. Learned Additional Advocate General Mr. Samuel Vanlal Shyata Changte has submitted that the land for construction of Howland to Dawn Road has been donated by the villagers, has been donated by the landowners voluntarily. However, he submits that he could find out the land donation agreement only in respect of petitioner number 4 and 17, and as regards other petitioner, no such land donation agreement could be traced out. Now, whether these land donation agreements are sufficient in law to divest them of their ownership rights?
Coming to page 151, my lord, that is the memorandum of understanding.
151 of?
Affidavit in opposition of the state, my lord.
Yes.
This is with regards to the petitioner number 4, my lord. This memorandum of understanding was made on 4th of February 2020, my lord.
What it says?
At point number 1, my lord, that the first party is landowner with transferable right of 2.5 acre of land bearing pass number 13 of 1996 in village Howlong, block Longlei and district Longlei. That the first party hereby grants to the second party above said land for the construction and development of the PMGSY road in the village Howlong to Dawn for the benefit of the villagers and appropriate.
No, my query is,
yes, brother.
Suppose such a memorandum of understanding is executed by landowner.
Yes, brother.
Will it can it be regarded as waiver of their rights which statutes gives to them?
My lord, his waiver of rights, he has willingly signed the agreement, my lord, when he is willing to donate the particular portion of the land.
But for donation, the modes are recognized by the Transfer of Property Act.
Yes,
It has to be either gift, sale, or any other.
Yes, my lord.
This memorandum of understanding is not a recognized mode of transferring land.
And after this, my lord, what has transpired, my lord, is that the affidavit of land donation has also been signed.
Now, whether by affidavit land can be donated, again my query is there.
If I
Yes,
may,
ma'am.
Your Lordship. My Lord, Section 100 of the Mizoram Land Revenue Act 2013.
100 of?
Mizoram Land Revenue Act.
Yes, what it says?
My Lord, it says that all valid transfers of land shall be compulsorily registered within the state under the provisions of the Indian Registration Act 1908 as adopted in the state of Mizoram by the Registration Mizoram Amendment Act 1996 as amended from time to time and subject to the provisions of the said act. However, my Lord, in the instant case, these affidavits have not been registered. These documents are not registered documents under the Indian Registration Act. And another thing is that, my Lord, in respect of the petitioner number 4, the affidavit signed by the petitioner number 4 is at page number 152. This affidavit pertains to another pass, which a different pass which the petitioner herein has claimed compensation money.
Okay.
If Your Lordship will see at page number 8, the petitioner number 4 has claimed compensation in respect of periodic pata number G322 of 1977. However, in page number 152, the said Kapliana had donated a land in respect of pass number 1313 of 1996, a different pass.
And which land you are agitating in this
My Lord,
writ
in
petition?
the instant case, if Your Lordship will see at page number 8,
What is the number?
periodic pata number 322 of 1977. G322 of 1977.
Okay.
This is a different pass.
Learned Calica, last line.
And, my Lord, in respect of the petitioner number 17, name of petitioner number 17 is R. Nunciami. This is a female. However, if Your Lordship will see page number 103 of the affidavit filed by the state respondents, this is a male person, R. Nunciama.
Page number?
Page number 103 of the state affidavit.
This is petitioner number?
17 is a female, Arlal Siami, whereas the affidavit at page number 103 is signed by a male person, Arlal Siama.
In page number? Oh, yes.
In any event, my Lord, in order to be a valid transfer of land, my Lord, that has to be done under, the document has to be compulsorily registered, my Lord, which is otherwise not done in the case of the affidavits.
What was the last para? Stop. What else is your submission?
My Lord, I do not have an objection to the prayer of spot verification, subject to the validity of the periodic pattas, my Lord, as well. Because it's a periodic patta, my Lord. It has to be valid.
Okay. Learned additional AG, however, fairly submitted that the state respondent is not averse to the prayer of the petitioners for spot verification to ascertain as to whether the lands belonging to the petition, construction of roads, construction of Howlong to Dwan roads under PMGSY. He, however, submits that the payment of compensation, if any, would be subject to only finding that only subject to possession of a valid periodic patta by the petitioners. Stop. Learned counsel for the petitioner, in response to the submissions made by learned additional AG, has submitted that the mode of transfer of land by way of an affidavit and by way of an unregistered agreement is not recognized by law. It is neither recognized by the Transfer of Property Act nor by the Mizoram within bracket Land Revenue Act 2013. He submits that section, which section?
100.
Section 100 of the Mizoram Land Revenue Act 2013 provides that all valid transfer of land shall be compulsorily registered within the state under the provisions of Indian Registration Act. However, in the instant case, the affidavit as well as agreement relied upon by the state respondent are not registered agreement. He further submits that the affidavit of He further submits that the affidavit for land donation referred to by the state respondent as affidavit executed by respondent number 4. Respondent number 4 is in
Petitioner number 4.
by the petitioner number 4, even if it is taken on its face value, is in respect of a different land pass. He submits that in the instant case, the petitioner number 4 is agitating against non-payment of compensation in respect of land covered by periodic patta number 322 of 1977. Is it right?
No.
Whereas the affidavit annexed by the state respondent in their affidavit in opposition pertains to a land under land pass number 13 of 1996, and hence he submits that same is of no use to the state government, state respondent. He further submits that in respect of the respondent number 17, petitioner number 17, the affidavit bears signature of one R. Lal Nan Syama, who appears to be a male, whereas the name of the petitioner is R. Lal Nan Syami. This is your submission, no?
Madam.
Hence, he submits that said affidavit also does not comes to the aid of the state respondent. I have considered the submissions made by learned counsel for both sides and have gone through the materials on record. Apparently, it appears that the affidavit of land donation annexed by the state respondent in their affidavit in opposition does not pertain to the any of the present petitioner in respect of the land over which they are claiming compensation. As submitted by learned counsel for the petitioner, the affidavit for land donation in respect of this petitioner number, whose name is different?
17, madam.
Petitioner number 17 is concerned. It appears that though the name of the petitioner number 17 is R. Lalnan Syami, however, the said affidavit of land donation / memorandum of understanding has been shown to have been signed by one R. Lalnan Syama. Moreover, the affidavit / memorandum of understanding in respect of petitioner number 4 also appears to be in respect of a land covered by land pass number 13 of 1996, whereas the said petitioner is claiming compensation in respect of land covered by periodic patta number 322 of 1977, which is a different land. Stop. Otherwise also, in respect of other petitioners, the state respondent is not able to show any document regarding donation of their land for construction of Howlang to Down Road. Stop. If the land of the petitioners has been utilized, if the land of the petitioner is found to have been utilized for construction of the aforesaid road, they are entitled to get due compensation for such utilization as under Article 300A of the Constitution of India, no person can be deprived of his property save by authority of law. Stop. In any view of the matter, considering the fair submission of learned additional AG regarding his no objection to the spot verification, no objection to the prayer of spot verification of the land of the petitioner to ascertain whether same has been utilized for purpose of construction of how long to Dwan Road, this writ petition is disposed of with a direction to the state respondent to conduct spot verification of the lands of the petitioners to ascertain as to whether said land have in any manner been utilized for the purpose of construction of how long to Dwan Road, within when you will be
3 months, Lala.
within 3 months from the date of this order. In such spot verification, the petitioners and their representative shall also remain present. Stop. If after such spot verification it is found that the petitioner's land are utilized, have petitioner land have been utilized for construction of how long to Dwan Road, then the state respondent shall take appropriate steps for payment of due compensation to the petitioner in pursuant to the prevailing law in that regard. With above observation, this writ petition is disposed of.
Hearing list, item 2.
Lordship is very simple here.
It's a simple matter, but provided time permits, Lordship.
No, everything is simple for lawyers.
No, Lordship, it will be simple for Lordship as
No,
well.
no, but today time may not allow us.
Lordship,
Because
then-
it will take some time and I propose to dictate part of the judgment in the court.
Okay, Lordship.
We'll wait for it, Lordship. We'll wait.
Then you have to wait till 4:30. I'll ensure that you wait till 4:30.
Lordship, for me it would be convenient if it is fixed sometimes in March, in between 1st to 9th of March, any date.
Yes,
Because
Let that be for this item number 5.
And if item number 6 and 7 are very urgent, then
There's urgency in the sense it's a matter pertaining to land acquisition, which was of 2009. And the approval of the award was 2016. And the landowners have been made to suffer.
you choose a date in the next week.
no, Lordship, it will be difficult for me because I cannot appear virtually. Might have to show some.
You are for
yes, sir, Lordship. So either 1st to 9th or any day 1st to 9th. It's what my senior has said, learned senior has said, it's a simple matter, but as Lordship has said that there would be paucity of time, so I would pray for 1st to 9th any day.
Yes, make a letter. You have choose a date between 1st to 9th.
Any day, 1st to 9th.
1st to 9th March.
Yes.
5th of March.
Yes, Lordship. Oblige.
Reflect the names of the council. Due to paucity of time, this matter could not be taken up for hearing today. Let this matter be listed on 5th of March.
Yes. All the three?
All three.
Serial number 5 also.
All three.
Lordship just want permission for 5 to file an affidavit.
In file, learned counsel for respondent number
5.
5-6 per some time for filing affidavit in opposition. The prayer is allowed.
Yes.
Same shall be done before the next date fixed. Yes.
Oblige, Lordship. Oblige.
Let it remain as it is. Yes. Now we can